All right.
Ms Fenwick.
Yes, my lords, there are 4 overlapping issues as between the appeal and the cross appeal. First is the question of what, if any, common law powers the court has in respect to immovables. Secondly, there is a question whether, if the court does have a discretion in respect of immovables, it should exercise that discretion at all in favour of this trustee, even before getting to the second stage of the nature of any such assistance. Thirdly, there is a question of recognition, whether or not the learned judge was right to recognise the trustee in the circumstance of this case at the end of the hearing which took place in April of this year. And fourthly, the question as to whether or not the learned judge was correct to decline to set aside the order of Mrs Justice Falk permitting a variation of the worldwide freezing order and allowing the property both to be sold and to be charged in the meanwhile to Mishkon Duria in respect of Mr Bedzhamov's fees. Linked to that issue is the question of what, if any, direction or observations this court should make now if it is, against all my submissions, of the view that the recognition should remain and that some form of assistance should be granted either in respect of immovables or otherwise. The way in which I propose to address those is I will say something very briefly by way of introduction for 2 or 3 minutes. My learned friend Mr Robbins will then address the court in respect of the law on immovables, and I will then deal with the rest when he's finished. But by way of preliminary observation, may I take issue with one of the submissions made by my learned friend, Mr Davis, namely that there is no other way in which the creditors of Mr Bedzhamov, if there be such creditors, can obtain rights over Belgrave Square. And he submitted that because of the Russian insolvency and because creditors had proved in that insolvency, it would need some new creditor to come along before anything could be done. Well, that overlooks crucially the fact that in late 2018 proceedings were issued by one of the 3 current creditors, namely Vneshkom Bank, VPB, which obtained a freezing order relief and a search order from my Lord Justice Arnold, sitting as Arnold J, in March of 2019, and has then proceeded for the next 2.5 years to run a case against my client seeking £1.3 billion, the result of which would have been, had they succeeded, may still be if they succeed, that they would be in a position to bankrupt my client in his jurisdiction and would then have unassailable rights to all his assets, including his rights over Belgrave Square. That process, which we'll need to look at in a little bit of detail in respect of both recognition and discretion, has been rudely interrupted after multiple visits to the Chancery Division, one earlier outing to the Court of Appeal, very careful case management directions from Mrs Justice Falk, and a very expensive and exhaustive search order procedure. by the trustee arriving belatedly and saying, actually, everything that Mr Bedzhamov has been fighting to defend and VPB has been fighting to obtain by way of a judgment belongs to me anyway. And Mr Bedzhamov must do as I say. We say that VPB, we would submit the at least acquiescence of the trustee, if not more, and we don't know, took the right course in concluding that if they wanted Mr Bedzhamov's assets in this jurisdiction, they should bring proceedings against him and obtain a judgment.
But it's the judgment that would found the application for bankruptcy order.
Yes.
And that would be a new creditor in Mr Davies's terms, because although you're quite right to say that they're one of the existing creditors in the Russian bankruptcy, they would be relying upon their standing as a judgment creditor in order to bring any bankruptcy proceedings in this country.
Yes, but there are 2 points to that. Firstly, as we will see in due course, VPB, when applying to your lordship for the WFO, said in terms that they would not be seeking to claim in this jurisdiction the unjust enrichment claim, which is, of course, the largest claim in this bankruptcy which the trustee represents. And secondly, that it is, I think, common ground that having proved in the bankruptcy in Russia, VPB should not have brought proceedings against the bankrupt in any jurisdiction, certainly without permission of the trustee. But, my lords, we'll come to that in due course.
But that was, they brought the proceedings before the trustee.
Sorry?
So, can you remind me the chronology? When was the trustee appointed?
2018.
Was that before or after the proceedings have commenced?
Before.
Before, right, okay.
And I'll be showing the court...
But is it the same debt?
I'm so sorry?
Is it the same debt? Because you say they excluded the unjust enrichment claim, so to that extent it's not the same debt.
What they said was, and we'll have to look at it in detail, so I don't want to get ahead of myself, but in respect, the unjust enrichment debt, so-called, for some 3 billion rubles, is the second of the 3 debts currently in the Russian bankruptcy. When the claim was brought for 1.3 billion, Mr. Phillipson explained, or sought to explain to the court, how and why that judgment had been obtained in circumstances where we say he was telling this court that it was accepted that it was not properly obtained, and then said, we will not be pursuing it in these proceedings. So he excluded it from the claim for 1.3 billion pounds expressly, but we'll have to look at that in some detail.
All right.
Lord, that was what I wanted to say by way of introduction, save only for this, that when we come to look at what Mr Justice Snowden was doing and why the hearing in front of him was expedited, it was expedited because Mrs Justice Falk recognised the urgency of Mr Bedzhamov being able to realise the asset in Belgrave Square in order to be able to continue to defend the proceedings and meet the trial date of January 2022. Because it was clear that the trustee was challenging the right to sell Belgrave Square or to charge it, it was a matter of urgency that that should be determined, so that the hearing proceeded at short notice. And we will be saying that as we submitted on several occasions to the learned judge, apart from the question of the Immovables Rule, unless he was persuaded, as we sought to persuade him, that the trustee should be sent packing in any event, then any question of recognition would require a further hearing and further consideration with further evidence. But I'll show that to you in due course. Lord, I'm now going to sit down, if I may, and allow Mr. Robbins to make submissions on immovables.
Mr. Robbins.
My Lords, just to mention at the beginning, the issue is to the scope of this appeal, because it may not be something that's on your Lordship's radar. The Russian trustee has issued 3 separate applications. The first related solely to immovable property. That was by application notice dated the 19th of February this year. Secondly, there is an application notice that seeks relief in respect of movable property generally. That is raised by an application notice dated the 3rd of September this year. And thirdly, there is an application notice that seeks relief in respect of any proceeds of sale of the Belgrave Square property. That was raised by way of an application notice dated the 13th of September this year. And the reason it came about that way is because after the first of those applications was issued and argued and decided by the judge, points were raised at the consequentials hearing in respect of movable property and the proceeds, and Mr Justice Snowden made clear that he hadn't decided those and that any applications in respect of those matters should be issued and listed before Mrs Justice Falk, and that you may have picked up from paragraph 2 of the order under appeal, where the judge provided that any applications in respect of movables should be listed before Mrs Justice Falk, and that is where the applications in respect of movable property generally and the proceeds of sale have ended up. So the only point that has been argued and decided, the only point that is under appeal is the issue as to movable property. The other matters remain outstanding, yet to be argued or subject to any decision at first instance. And within the ambit of this appeal, I propose to cover 5 topics. The first is to explain the Immovables Rule, what it means and what its implications and consequences are, and I think I can take that fairly briefly. Secondly, to explain about the statutory provisions which are or which operate as exceptions to the Immovables Rule. And thirdly, to set out the position where none of those statutory exceptions is applicable. Fourthly, to deal with the concept of common law assistance and to explain to your Lordships why it can't overcome the Immovables Rule or operate as an exception to it. And then finally, to deal with various miscellaneous points on which the trustee relies. So, starting with the first of these topics, the Immovables Rule, which, as your Lordships know, is an orthodox rule of private international law. Because its existence isn't an issue in this appeal, I think I can take it relatively quickly by reference to our skeleton argument, which you'll find in the core bundle at tab 4. It's the second page of the skeleton argument, which is page 53 of the core bundle. And as we set out in paragraph 6, the Immovables Rule is a fundamental rule of English private international law, which has 2 aspects. The first is the jurisdictional aspect. A foreign court doesn't have jurisdiction to make orders affecting immovable property in England. And I don't need to take you to Dicey and Morris, but for your note, it's in Authorities Bundle 4 at tab 81, where Rule 47.2 provides that a court of a foreign country has no jurisdiction to adjudicate upon the title to or the right to possession of any immovable situate outside that country. The second aspect of the Immovables Rule is the governing law or proper law aspect, namely that foreign law has no effect on immovable property in
Yes,
England.
that statement neither reflects Dicey nor is accurate, because what it fails to recognise is the exception stated in Dicey, which is that foreign contract law may affect immovables.
Yes, there may be personal obligations, but the succession...
So the assertion that foreign law has no effect, it simply isn't correct. The starting point is that the lex situs will be English law that will govern dealings in immovable property.
Yes.
But doesn't mean to say that foreign law never comes in. The most obvious situation where it does come in is where it's foreign contract.
That's right. We're not, of course, dealing with a contract. We're dealing with a...
To be sure, but one has,
Oh, yes.
one has to be careful, or
No, that's-
broad general propositions, when in fact the true proposition is narrow.
That's a fair point, and perhaps it's because we're concerned with the specific application in bankruptcy that we've set it out in that way. Because when it comes to matters of bankruptcy law, the effect of the Immovables Rule is that a purported succession to a foreign immovable, to an English immovable under a foreign bankruptcy law will have no effect. In England, it won't be recognised or given effect by the English court. And to give you a few illustrations of that, if I could ask you to turn up Authorities Bundle 1. At tab 3, there's the decision in Osborne and Adams from the United States. You'll see from the head notes that an insolvent debtor in Connecticut assigned all his property, including certain lands in Massachusetts, in trust for the benefit of his creditors under the provisions of a statute of Connecticut. And it was held that the statutory assignment in Connecticut was void in regard to land in Massachusetts, the title to real estate being exclusively subject to the laws of the state where it lies. And the relevant passage is in the judgment of Mr Justice Wilde at page 247 of the report, just below the first hole punch. And if I could just ask you to read the first paragraph. And so you see the decision is that the statutory assignment in regard to real estate situated in this Commonwealth is merely void. It can neither pass a title nor aid one otherwise defective. While we're here, if I could ask you just to look at tab 11, decision from Canada and Arnold and Georgy Bedzhamov Lumber Company Limited. It's a decision concerning land in Canada. There were insolvency proceedings in New York under the Bankruptcy Act of the United States. There was a statutory assignment under that act to a trustee for the benefit of the creditors, and the question was whether that statutory assignment had any effect in Canada. And you'll see it was held just below the second hole punch on the first page, that a bankrupt assignment made under the provisions of an act of the Congress of the United States of America will not transfer immovable property in Canada. And if I could ask you to turn, looking at the numbering at the top of the page, to page 6 of 13. You'll see in the first marked paragraph, 4 lines from the end of that paragraph, Justice Ritchie says the principle is too well established to be now questioned, that real estate is exclusively subject to the laws of the government within whose territory it is situate. Mr Sori says, so firmly is this principle established that in cases of bankruptcy, the real estate of a bankrupt situated in a foreign country is universally admitted not to pass under the assignment. And at the second hole punch, the passage from Story is quoted that the universal consent of the tribunals acting under the common law both in England and America is in a practical sense absolutely uniform. All the authorities in both countries, as far as they go, recognise the principle in its fullest import that real estate or removable property is exclusively subject to the laws of the government within whose territory it is situate. And at page 7, the next page, I could ask you to read the first paragraph of the decision of Justice Strong to the same effect. And you see the two propositions which the authorities of courts and judges as well as text writers is against are that the jurisdiction of the Foreign Bankruptcy Court extended to lands in this country, or at least that it imposed upon the bankrupts a personal obligation so as to deal with the land here as to bring them under the control of the foreign bankruptcy, an obligation which upon principles of international comity, it was said, our domestic court tribunals would enforce. Justice Fournier and Justice Henry agree. If I could just show you finally on this authority in the decision of Justice Henry at page 12 of 13, the second paragraph, beginning, I've considered all the binding authorities as to both propositions and can find none to sustain them. And he says a general assignment under the bankruptcy laws of the United States cannot affect or cover lands in this country, although as to movable property the law may be different. An assignment in bankruptcy in another country will not affect lands in the United States, neither will it in England. No reason has been given why we should hold differently here. I don't think I need to take you to too many of these, but perhaps I could just mention while we're here, you'll find precisely the same principle being stated in the New Zealand decision Bettel at tab 15 and the Australian decision Australian Mutual Provident Society and Gregory at tab 19. And the way it's put in the Australian case at tab 19 at page 626 of the report by Chief Justice Griffith is that the respondent, Green, the South African Trustee and Bankruptcy, never acquired any right to the bankrupt's interest by virtue of the sequestration.
Sorry, where are you reading from? 626.
So at 626 at tab 19.
I see, yes.
You'll see it at the marked passage.
Yes.
Never acquired any right. So certainly, I of course take my Lord Justice Arnold's point that the propositions shouldn't be stated too broadly in such a way as to omit the recognised exceptions. But certainly, when it comes to matters of bankruptcy, the effect of the Immovables Rule is that a purported succession to the land under a foreign bankruptcy law will have no effect under England and won't be recognised. And that brings me to the next topic, the statutory exceptions to the Immovables Rule, or the provisions, the statutory provisions which operate as exceptions. And the first and most important is undoubtedly section 426 of the Consultancy Act, which you'll find in Authorities Volume 4 at tab 77. And it's the fifth page behind that tab.
Did you say tab 77?
Yes, that's right.
Thank you.
And it's the fifth page. And there are two subsections that are relevant for present purposes. The first, which my friend Mr Davies mentioned, is subsection 4, just above the second hole punch. The courts having jurisdiction in relation to insolvency law in any part of the United Kingdom shall assist the courts having corresponding jurisdiction in any other part of the United Kingdom or any relevant country or territory. And we've mentioned some of the relevant countries and territories in paragraph 17 of our skeleton arguments. They include Australia, Canada, New Zealand, South Africa, and so on. They've been designated by the Secretary of State by statutory instrument As you know, it's common ground that Russia is not a relevant country or territory for these purposes. Subsection 5 is then the key provision. It provides, as you'll see, that for the purposes of subsection 4, a request made to a court in any part of the United Kingdom by a court in any other part of the United Kingdom or in a relevant country or territory is authority for the court to which the request is made to apply in relation to any matters specified in the request, the insolvency law which is applicable by either court in relation to comparable matters falling within its jurisdiction. And it's that reference to comparable matters falling within its jurisdiction which is the key, because it operates to domesticate the foreign insolvency proceedings by...
Well, I accept that that's the effect that's been attributed to it in case law, but it doesn't leap out of the wording of the statute, particularly when you look at the last sentence. In exercising its discretion of this subsection, a court shall have regard, in particular, to the rules of private international law. And of course, the Immovables Rule, as you rightly said earlier, is a rule of private international law. So one might have thought, just reading the statute, that this was all subject to the Immovables Rule, although that's not in fact how it's been interpreted and applied.
Your Lordship is quite right. That provision has been, that particular, the wording at the end that I didn't read out, referring to having regard to the rules of private international law, has been said in the authorities to be a provision of some obscurity. I can dig out the references. They're referred to, I think, in HIH, possibly in other cases as well. Lord Collins, in a case called Television Trade Rentals, held that it's a reference, again, possibly a rather oblique one, to the concept of a sufficient connection, and that in deciding whether to apply the foreign insolvency law or the English insolvency law, you have to look at the connections between the case and each of the rival jurisdictions to decide as a matter of discretion which to apply. But it's certainly not saying, couldn't possibly be saying, that you can't grant relief under section 423 if it would be otherwise prohibited, because that would be to give the section no impact at all. As my Lord Justice Arnold rightly says, the reference to comparable matters has been held to effectively authorise the English court to do whatever it could have done if the foreign insolvency proceedings were taking place locally within its jurisdiction. So the English court is entitled to ask, well, what could I have done if this were an English bankruptcy, if I were dealing with an English trustee in bankruptcy? So the powers which are unlocked by a letter of request under section 426 include the powers that could be exercised by the English court for the benefit of English bankruptcy trustees and English liquidators. So in other words, the English court gets to ignore the foreign elements. And the question which arose in Hughes and Hanover, and perhaps it makes sense to go to that next, was whether...
is that volume 3? I can't...
Yes, that's right. It's no, sorry, volume 2, tab 41. The question posed by Hughes and Hanover was to ask, well, section 426 opens a door, but opens a door to what? Does it merely enable the court to exercise its powers under statutory provisions of English insolvency law? Or does it also open the door to the exercise by the court of the general powers that it would have in the case of a purely domestic insolvency process, including its common law or equitable powers? And the reason...
So in that sense, it's a gateway provision.
Exactly. It's a gateway. It would be a gateway to everything, not just a narrow gateway, but a gateway to all of the court's powers exercisable in purely domestic provisions. And at page 499 of the report, at the bottom of the page, you can see why the issue arose, because in subsection 10 of section 426, insolvency law is defined in A by reference to provision made under this Act, in other words, the Insolvency Act, 1986, or sections 6, 10, 12, 15, 19, 20, with Schedule 1 of the Company Directors Disqualification Act. And so the argument was, well, it's a gateway, but it's only a gateway to the exercise of the English court's statutory powers under the specified provisions of English statutory insolvency law. And you can see the decision of Mr Justice Knox at first instance at 504, where a few lines below B, in the quoted passage, it says, "I am of the opinion that the section should be construed so as to include the court's ancillary jurisdiction, where it exists in connection with the protection of the processes of liquidation, even though the remedy derives from the court's general power to grant injunctions under section 37. And then just a couple of lines above D, the granting of the injunction is technically an exercise of the court's power to restrain abuses of its processes, and as such not specifically authorised by any particular section of the 1986 Act or the rules. Although the petition itself, if and when heard, would be dismissed because the petitioner was not a creditor within and did not therefore have a debt within section 123 of the 1986 Act." So if we then turn to what Lord Justice Moritz said on page 516, just above F, he makes the point that I was just making when he says the earlier statutory provisions referred to the request of the other court being sufficient to enable the English court to exercise such jurisdiction as it could exercise in regard to similar matters within its jurisdiction. And he says the earlier references to jurisdiction in bankruptcy and jurisdiction in bankruptcy and insolvency were used to identify the courts to which reference was being made, but the jurisdiction which might be exercised was not so limited. Thus, a request to the High Court in England for assistance in a form it could not give did not inhibit it from exercising its general equitable jurisdiction to appoint a receiver. The fact the jurisdiction did not to do so did not arise under the Bankruptcy Act for the time being in force was immaterial. And then he says the position is the same under section 46. The reference to insolvency law serves to identify the courts in any part of the United Kingdom on which the obligation is cast. Those courts have their usual jurisdiction and powers as such courts. In England, they're the High Court and certain county courts. There's nothing in section 426 to exclude the general jurisdiction and powers vested in those courts as such under the laws of England and Wales. The purpose of subsection 5 is not to reduce that jurisdiction or those powers, but for the purpose of subsection 4 only to extend them. Thus, a court in England faced with a request from a relevant court may, in respect of the matter specified in the request, apply either the insolvency law of the relevant country concerned or its own insolvency law. And then over the page, just below, just above B, he says that the concluding words of subsection 5 introduce the hypothesis that the matters specified within the request fall within the jurisdiction of the court applying the insolvency law under consideration, insofar as comparable matters would do so. It's the statutory hypothesis. He says, thus there is available to the court in England, when asked for assistance by the court of a relevant country under section 46A, its own general jurisdiction and powers, and either B, the insolvency law of England and Wales as provided for in the Insolvency Act, specified sections of the CDDA and subordinate legislation, or C, so much of the law of the relevant country as corresponds to that comprised in B. He concludes that construction gives effect to the intention of Parliament without distorting the language of subsection 10. So the effect of the decision is that Section 426 is a gateway, not merely to the particular statutory provisions of English insolvency law, but also to the court's general powers, which can then be exercised on the basis of that hypothesis explained by Lord Justice Morritt, that the matters specified in the letter of request are taking place locally. So it enables you to say, well, what could I do if this were an English trustee in bankruptcy asking me for assistance in respect of these matters? And Lord Justice Morritt made clear in his reference to earlier statutory provisions that Section 426 isn't new. It derives from Section 74 of the Bankruptcy Act 1869, which was reenacted subsequently as Section 118 of the Bankruptcy Act 1883, and then Section 122 of the Bankruptcy Act 1914. And for your reference, Lord Justice Morris sets all that out at the bottom of page 506 of the report. And materially identical provisions were in force at various times in other jurisdictions. And I'm going to run, if I may, very briefly through the various decisions in which statutory provisions in the nature of Section 426 have been used to grant relief in respect of local immovable property to a foreign bankruptcy trustee from a relevant country or territory, essentially for two reasons. Firstly, to make the submission that the relief granted in each of these decisions was critically dependent on the applicability of a provision in the nature of Section 426. And secondly, to make the submission that relief in those terms in respect of local immovables is simply not available in the absence of a statutory exception to the Immovables Rule, such as Section 426. It is the applicability on the facts of these particular cases of a Section 426 type provision that makes all the difference and enables the relief to be granted by opening the door to the court's powers on the basis of the statutory hypothesis that the matters specified are occurring locally. And the first is Levi's Trusts, which you'll find in Authorities Bundle 1, tab 10. And this isn't the first case in which an order was made under Section 426 style provisions in respect of English immovables. But so far as any of us are aware, it's the first case in which it was said that it could be done.
Could you be very kind and just give me the tab number?
Tab 10.
Thank you.
And at the bottom of the second page, page 120 of the report, 3 lines up, you'll see that Section 74 of the Bankruptcy Act 1869 is set out. That's the relevant provision. And it's the wording which Lord Justice Morritt quoted in Hughes, enabling the English court to exercise such jurisdiction as it could exercise in regard to similar matters within its jurisdiction. And then at page 123 of the report, right towards the bottom of the page, 3 lines up, Mr Justice K read out Section 74 and continued, from the facts before me, I'm bound to infer that if the Chief Commissioner or the person who exercises the functions of what used to be called the official assignee in England had applied to the Court of Bankruptcy in England for an order in aid of bankruptcy in the colony to enable the assignee to receive the rents and profits of the property of which Samuel Levy is tenant during the rest of the life of Samuel Levy, that order would have been made as a matter of course. And in my submission it is clear from that the conclusion is based entirely on section 74, which the judge has just quoted. The next is Fogarty at tab 17. So at the bottom half of the page, it's involved.
Sorry, tab 17.
17. Sorry.
Yes.
It's involved immovable property in Queensland and a bankruptcy in New South Wales. A letter of request was issued from the Court of New South Wales to the Court of Queensland asking for immovable property in Queensland to be vested in the New South Wales trustee. And just a few lines up from the bottom, the penultimate paragraph, you'll see files for the petitioner submits. The application is made under section 118 of the Bankruptcy Act 1883. And Chief Justice Cooper made an order as prayed. So again, it's an order under a specific statutory provision in the nature of section 426. The next case is Bolton, which is at tab 24. And this concerned immovable property in Ireland and a bankruptcy in South Africa, with a letter of request from the South African court to the Irish court asking for the Irish immovable property to be vested in the South African trustee. And on the second page, in the middle of the page, you'll see that Ellison, for the trustee of the insolvent estate, applied for an order under the Bankruptcy Amendment Ireland Act 1872, vesting in the trustee all the estate and interest of the insolvent in the property specified in the notice of motion. And the wording of section 71 of that act is then set out on page 327 of the report. And you'll see it's the familiar section 46 style wording which enabled the Irish court to exercise the jurisdiction and powers that it could have exercised in regard to similar matters falling within its own territorial jurisdiction. And at page 329, at the first hole punch, you'll see that Mr Justice Dodd said that he therefore placed at his service as required by the section the machinery of this court to be used in aid of and auxiliary to the Court of South Africa as fully as it could be used in the case of a bankruptcy in this country, which is the statutory hypothesis to which Lord Justice Morritt referred in Hughes and Hanover. And again, in my submission is absolutely clear that it's a case which is critically dependent on the availability of a statutory provision in the nature of section 426. The next case is Osborne at tab 27, which concerned immovable property in England and a bankruptcy in the Isle of Man. There was a letter of request from the Manx court to the English court asking for the English immovable property to be vested in the Manx trustee, alternatively for the Manx trustee to be appointed receiver of the English immovable property. And you'll see section 122 of the Bankruptcy Act set out at the foot of the first page in the footnote. And at the top of page 193, sorry, very bottom of page 193, Mr Justice Farwell said the application which is made to the court today is made under section 122 of the Bankruptcy Act, which provides his lordship read the section and continued. And then over the page, 3 lines down, where he refers to section 122, he says it is under that section that I'm now being asked to make the order. And then in the middle of the page says, I think it's clear that I'm bound in a proper case under section 122 to assist the court in the Isle of Man in the bankruptcy. And the point which he goes on to make on section, on page 195 and 196 is to say, well, I'm asked to make an order vesting the property in the Manx trustee, alternatively appointing a receiver. Do I have power to make that sort of order in a purely domestic case? And in the middle of page 195, he decides that he doesn't have the power under section 122 to make a vesting order, because that's not the sort of order that the English court has power to make in a purely domestic case. He says, what jurisdiction in bankruptcy I have to vest property in a trustee in bankruptcy in another country I do not know. The effect of an order of adjudication in this country is to vest ipso facto the property of the bankrupt in the trustee. But that does not give me any power to vest the property of the bankrupt in a trustee in a bankruptcy in another country.
So is what he's saying that because the vesting happens ipso facto, there's no scope for the court separately to order vesting?
Exactly.
That's
if this section enables me to do what I could do in a purely local case, can I do this in a purely local case? No,
because it would have happened already.
Exactly. But then he goes on at the bottom of this page to say that I have jurisdiction to appoint a receiver in bankruptcy. There can be no doubt. So he's saying, well, I do have a power in a purely domestic case to appoint a receiver. So on the statutory hypothesis, asking what could I do if this were all taking place locally, I have that power to appoint a receiver and can exercise it under section 122. And again, in my submission, it's clear that all this depends on the fact that the gateway provision of section 122 was available on the facts of the case, and there was a letter of request from the Manx court. The next case is Jackson, which is in Authorities Bundle 2. So could I just turn my back for a moment? I'm going to have to ask the associate to reassemble my point of one.
Oh.
Your lordships can put bundle away for now. It's tab 32. It concerned immovable property in Northern Ireland and a bankruptcy in the Republic of Ireland. And in the head note towards the bottom of the page, you'll see held the Northern Ireland Court had power under section 122 of the Bankruptcy Act 1914 to act in aid of and be auxiliary to the High Court in the Republic of Ireland in its bankruptcy jurisdiction. And you'll find that set out on page 70 of the report. As you know, it's a section 4612 provision, so this case is just another example of that statutory provision at work. Then tab 34, rear debtor ex parte Viscount of Law Court of Jersey. This was immovable property in England with a bankruptcy in Jersey, and section 122 of the 1914 Act is set out at the bottom of page 688 at J. The letter of request.
Sorry, I'm looking at the wrong page. What page?
I've got it in tab 34.
Yes.
Called.
I've got the case, and then you gave a page number.
Bottom of page 667.
Yeah.
Sorry, 668.
Yeah.
Maybe I gave the wrong reference to section 122. And then the letter of request from the Jersey court is on page 669. And you'll see from page 670 the lined passage at the bottom of the page around H. The bankrupt was arguing that section 122 didn't apply. He was arguing that the Jersey court wasn't a British court within section 122. And that was rejected at 671J, where it was held that the Royal Court of Jersey was a British court within the meaning of Section 122. So Section 122 applies and the judge grants assistance under it. But the unspoken premise of that is obviously that if, as the bankrupt had contended, the Jersey court wasn't a British court, then Section 122 wouldn't be applicable, and the assistance that had been sought couldn't be granted. That entire debate would obviously have been entirely academic if the non-applicability of Section 122 made no difference, as is contended by the Russian trustee in this appeal. The next case is Radich at tab 44, a decision of the Federal Court of Australia. And on page 797 of the report, sorry, that's a Duff reference, 787 of the report, you'll see in the middle of the page, section 29.2 of the Australian Act is set out, and that's the equivalent of our section 426 subsection 4. And then below that, at the second hole punch, is the equivalent of our subsection 5. Enabling the court to exercise such powers with respect to the matter as it could exercise if the matter had arisen within its own jurisdiction. And the significance of that provision is explained on page 801 of the report in the decision of Mr Justice Drummond, where he says at the bottom of the page, it's well established that the assignment of all the bankrupt's property, real and personal, wherever situate, the representative of his creditors, which is affected by the foreign law, upon the making of an adjudication by a foreign court having jurisdiction over the bankrupt person, will never be recognised in Australia as operating as an assignment of the bankrupt's Australian lands. Notwithstanding this, English and Australian bankruptcy courts, while not recognising the foreign trustee's title to recover in his own name the bankrupt's lands locally situated, have long acted under provisions such as Section 29 of the Bankruptcy Act 1966 to make available those lands to the foreign trustee so that they can be realised for the benefit of the creditors in the foreign bankruptcy. And it's clear from that he's referring to the Immovables Rule, and he's saying, well, it's Section 29 of the 66 Act, as it was in Australia, that makes all the difference. And then he explains on page 803, just below the first hole punch, after the reference to Hall and Wolf and re-heirs, he says it's true that Section 29 of the Bankruptcy Act 1966 does not create any new rights in the foreign trustee who enlists through his own bankruptcy court the assistance of the Australian court. It creates only new remedies for the enforcement of the rights which that trustee already has. And then dropping down 6 lines, he explains he already has those rights under the foreign decree when the foreign law operates as a universal assignment to him of all the bankrupt's property wherever situate. All the section gives the foreign trustee is a remedy which he would not have apart from the section for enforcing those rights in Australia. So, in other words, the New Zealand trustee had rights under New Zealand law to Australian immovables, but without Section 29, he couldn't enforce those rights in Australia. Section 29, in other words, changes the position by giving a remedy which he would not have apart from the section for enforcing those rights in Australia. So as a result, in other words, relief in respect of immovables is not available in the absence of a statutory provision such as Section 29 of the Australian Act or Section 46 of the UK 1986 Act. And the final authority is at tab 48, Dick and Mackintosh, which involved immovable property in Australia and an English bankruptcy. There's a letter of request from the English court to the Australian court, and Section 29 of the Australian Bankruptcy Act 1966 is set out at page 292 of the report. You've seen it already in.
Could you give us the tab?
In Radich, it's at 48, my lord. And
Thank you.
You'll see from even the quickest glance at, for example, paragraph 8 and 9 on page 293 that the judge was making an order appointing the English trustee as the receiver of the Australian property under Section 29 on the basis that he could exercise his jurisdiction under that section on the statutory hypothesis that it's all taking place locally. So that's Section 46 and how it works by, as I said, domesticating everything and entitling the court to presume on the statutory hypothesis that it's all taking place locally. That's how that provision operates as an exception to the Immovables Rule. There's a further statutory exception in the form of the UNSA trial model law on cross-border insolvency as enacted in the form of the cross-border insolvency regulations 2006, which you'll find in the authorities bundle 4 at tab 79. And the operative provisions are in Schedule 1, which starts at page 5, going by the numbering in the top right-hand corner. In the definitions on page 8, you'll see in G at the bottom of page 8, a foreign main proceeding is a foreign proceeding taking place in the state where the debtor has the centre of its main interests. And then over the page at the top of page 9, H, foreign non-main proceeding is a foreign proceeding other than a foreign main proceeding taking place in a state where the debtor has an establishment within the meaning of subparagraph E, which is on the previous page and defines that term. Recognition is then dealt with by Article 17 on page 14. And right at the foot of that page, you see paragraph 2 of Article 17. The foreign proceeding should be recognised as foreign main proceeding if it's taking place in the state where the debtor has the centre of its main interests, or foreign non-main if the debtor has an establishment in the foreign state. And then page 17, what does that open the door to? Article 21, you see at the second hole punch. Upon recognition of a foreign proceeding, whether main or non-main, where necessary to protect the assets of the debtor or the interests of the creditors, the court may, at the request of the foreign representative, grant any appropriate relief, including, and over the page, E, is entrusting the administration or realisation of all or part of the debtor's assets located in Great Britain to the foreign representative or any other person designated by the court. And there's no distinction drawn there between movable and immovable property. It's a straightforward statutory provision where the CBIR apply to entrust realisation to the foreign office holder. So that's the other statutory exception to the Immovables Rule. The next topic is the position where none of the statutory exceptions is applicable, which is the case here. As you've seen, Section 46 applies only to insolvency proceedings in relevant countries and territories, and the CBIR apply only where the debtor has his comia or an establishment in the foreign country in which the bankruptcy proceedings are taking place. If there is no statutory exception to the Immovables Rule, then in our submission, and consistently with the judge's conclusion, it continues to apply in its usual form. so as to mean that the foreign bankruptcy trustee cannot obtain immovable property in England. And for that, if I could please take you to Volume 3 of the Authorities Bundle at tab 55, the decision of the Privy Council in Walker and Lundborg, delivered by Lord Walker, with whom Lord Hope, Lord Roger, Lord Walker, Lord Mance and Sir Christopher Rose agreed on the fact it involved immovable property in the Bahamas and a bankruptcy in Florida. And on page 8, using the remembering at the top of the page, you see from the penultimate line of paragraph 24 that Lord Walker says he's going to set out what he considers to be some uncontroversial points of private international law. And then in paragraph 25, he says, in the Bahamas, your Lordship have that, where there are no statutory provisions for cross-border assistance in insolvency with an international element involving the United States, under general principles of private international law, one country will usually recognise the status of a trustee in bankruptcy or similar officer appointed by another country, and will also recognise his title to movable but not immovable property situated in the recognising country. Mr. Walker's interest in the property was immovable property, even if under Florida bankruptcy law, Mr. Walker's worldwide estate, movable and immovable, vested in his trustee, courts in the Bahamas would not recognise the trustee's title to immovable property within its jurisdiction. So, in other words, if there's no statutory exception to the Immovables Rule, it's applicable, and it's not possible to grant relief to a foreign bankruptcy trustee in respect of immovable property in England, simply because the Immovable Rule applies and there's no exception to it. The consequence of that is that
but obviously he was not purporting to deal with the possibility of any exceptions to the general rule. He was just here stating the general rule.
Well,
the question of whether there was any exceptions doesn't appear to be an issue.
He makes the remark on the underlying premise that the only exceptions that could make a difference are the statutory exceptions, which he says in the first line are not applicable in Bermuda. There's no statutory provision in Bermuda, so what you are left with is the position as he sets out.
He's setting out what he thinks is uncontroversial.
Yes.
And as a statement of general principle. He's not addressing the question of whether there might or might not be any exceptions to that general principle, is he?
He's saying that there aren't, because if there are no statutory exceptions applicable, then it's the immovable.
I could understand if he'd said it has been suggested there's an exception to this general principle. I disagree. He simply isn't addressing that, is he?
Well, perhaps I can come on to that because it's my next topic, and I'll explain, if I may, why there is no common law power that can operate as an exception to the Immovables Rule. And there are 3 points here on this fourth topic, 3 propositions. The first, which perhaps I can call proposition 4A, is that the court can't apply a statutory regime by analogy. And because that's, now it seems common ground, I can take it, I hope, fairly quickly. The first point I would just like to make is to show Your Lordship's why it was a...
Just before you do, you said there were 3 propositions.
Oh, would you like
Would
them
it be
all?
convenient just to list them so that I have them all down in
Absolutely.
one place?
4B is that the existence of a statutory regime is incompatible with a parallel common law power. And
Just hang on, sorry. Yep.
4C is that it's not possible to develop a common law power which conflicts with the orthodox rules of private international law.
Yeah, sorry. So back to your first one.
4A, you can't apply a statutory regime by analogy. I just wanted to show you why it was a fair comment for the judge to make in the supplemental bundle at tab 1. Page 2. This is the what's been referred to as the Immovables Application. And on page 2, you'll see the applicant seeks the following orders, and C had orders for the entrustment of the Belgrave Square Property, and used that very particular term, the very unusual term that you find in the cross-border insolvency regulations in Article 21(1)(e), Schedule 1, referring to entrustment. It's not a term you find in any of the case law. It's a specific statutory term. So the judge was entirely entitled to say, well, it looks like I'm being asked to apply a particular provision of the CBIR in circumstances where it's common ground that those provisions are not applicable. I'm in effect being asked to apply the statutory regime by analogy. And even though this point is not now pressed by Mr Davies, I do want to take you very briefly to Singularis in Authorities, Volume 3 at tab 64, to explain the reasoning underpinning that conclusion, because it's a point on 4A that also crops up on point 4B.
And if you gave me a page number, I'm afraid I've...
I haven't yet.
No, that's right.
Page 1709, paragraph 82. And you'll see that the liquidator's argument was that the common law rule of assistance in insolvency matters extends the application of local legislation even though as a matter of its legislative scope it does not apply to the case in hand. In the present case, the argument is that even if Section 195 Companies Act 1981 does not apply to foreign companies, it should be applied by analogy as if the Cayman Islands company were a Bermuda company. And then in paragraph 83, Lord Collins says the argument is not only wrong in principle, but also profoundly contrary to the established relationship between the judiciary and the legislature. To the extent it depends on some part of the opinion in Cambridge Gas, that was not only wrong in its recognition of the New York order regulating title to the Manx shares, as decided in Rubin, it was also wrong to apply the Manx statutory provisions for the approval of schemes arrangement by analogy or as if they applied. And then on page 1712, at paragraph 94, Lord Collins says that those courts which have relied on the passages he set out in Cambridge Gas to apply legislation which the legislature had not itself seen fit to apply are wrong, including the decision of the Chief Justice in the present case. And then at 95, he deals with a case called Re Phoenix, where, as he explains in paragraph 96, the EC insolvency regulation didn't apply, the Untitled model law didn't apply because the 2006 regulations were not in effect at the relevant time, and Germany was not a relevant country for the purpose of section 426. And he says at 97, that Mrs Justice Proudman decided the court had power at common law to recognise a foreign administrator and provide him with the same assistance as it was entitled to provide in a domestic insolvency, and that since proceedings to set aside antecedent transactions were central to the purpose of insolvency, the court had jurisdiction to authorise an administrator to invoke section 423. Applying Cambridge Gas, Mr Justice Proudman held the power to use the common law to recognise and assist an administrator appointed overseas includes doing whatever the English court could have done in the case of a domestic insolvency. And he says in 98 that that was wrong because it involved an impermissible application of legislation by analogy. And finally, at the bottom of 1714, he says he would humbly advise Her Majesty not only that the appeal should be dismissed, but also that to have allowed it on the basis of the liquidator's primary argument would have involved Her Majesty's judges in the development of the law and their lawmaking powers, which would have been wholly inconsistent with the established principles governing the relationship between the judiciary and the legislature, and therefore profoundly unconstitutional. So the judge was right to say there's no ability to grant relief at common law as if a statutory exception to the Immovables Rule were applicable. The next point, 4b, is that the existence of a statutory regime covering the territory is incompatible with a parallel common law power. It's not possible, in other words, to say, oh, well, section 46 doesn't apply, but we can do the same thing at common law. Before I take you to HIH, which is the key decision on this point, I'd just like to take you to Lord Collins' description of it in Rubin, in the authorities bundle at bundle 3, tab 63. And it's I'm taking you to this because it's the quickest way of explaining what it's about. At page 260 of the report, paragraph 49, Lord Collins explains that HIH doesn't deal with foreign judgments. It concerned 4 Australian insurance companies that were being wound up in Australia, and there were provisional liquidators in England. So there was a insolvency process going on in Australia and a parallel insolvency process going on in England in the form of a provisional liquidation. And the question was whether the English court had power to direct remission of assets collected in England to Australia, notwithstanding that there were differences between
I'm
the
sorry, I
English...
must be looking at the wrong paragraph. Which paragraph?
I'm sorry, my lord, it's paragraph 49.
Thank you.
Line 4, the question was whether the English court had power to direct remission of assets collected in England to Australia, notwithstanding there were differences between the English and Australian statutory regimes for distribution, which meant some creditors would benefit from remission while some creditors would be worse off. The House of Lords unanimously directed that remission should take place, but the reasons differed. The reasoning of the majority, Lord Scott and Lord Neuberger, with Lord Phillips agreeing, was based exclusively on the statutory power to assist foreign insolvency proceedings under section 426. The minority, Lord Hoffman, with whom Lord Walker agreed, also considered such a power existed at common law. And so it's the reasoning of the majority that I would like to take you to in HIH, which you'll find in behind tab 57 of Authorities Bundle 3. And at page 871 of the report, in paragraph 61, Lord Scott refers to the conflict between universalism and territoriality, and then says just below G, this conflict has been resolved by Parliament in enacting section 426. Section 426 has become part of the statutory scheme. The resolution achieved by section 426 does not apply to all countries. It does not apply where the principal winding up is being conducted in a country which is neither part of the United Kingdom nor has been designated by the Secretary of State as a relevant country or territory. The proposition that assistance and direction sought by the Australian court and the Australian liquidators in the present case could be given under an inherent power of the court without reliance on section 426, 4 and 5 is, in my respectful opinion, unacceptable. It would mean that the assistance and directions could be given in relation to a winding up being conducted in a foreign country that had not been designated a relevant country or territory by Secretary of State. It would constitute the usurpation by the judiciary of a role expressly conferred by Parliament on the Secretary of State. And that's why I say you get the overlap between my proposition 4A and what Lord Collins said about profoundly unconstitutional legislation from the bench by application of statutory provisions by analogy, and proposition 4B. It's the very existence of the statutory scheme that excludes the possibility of any parallel common law power.
Can I just test that one moment? There are two classes of case. There's the Section 46 type case where the country has been designated.
Yes.
And there's another type of case where the country has not been designated, so we're into the common law regime. It can't be the case, can it, that because Parliament has chosen to enact Section 426, under which certain countries can be designated, all powers are gone in relation to non-designated countries. The old powers must continue to exist, surely.
There is always the power of common law assistance, which as a developing principle foresees is very limited because it is subject to orthodox principles of private international law and indeed any other substantive law or policy of the assisting court. But yes, you couldn't say, oh, merely because I can, I could in theory give this sort of relief under Section 426, I can't give this sort of relief at common law. The difference is that the common law relief is, as I'll explain in a moment, is more limited. What you can't do under the common law jurisdiction is to develop a principle of assistance that would, for example, domesticate the foreign insolvency proceedings by saying, well, we'll do whatever we could have done in a purely domestic case, as if the foreign trustee were local.
So just to understand the significance of the submission, you don't say, well, if we find an old case where such and such a power was exercised in a common law context, that power has now gone because there is now a statutory regime. What you're doing, in effect, is discouraging us from trying to develop the common law.
Yes. Well, it's put in those terms in my learned friend skeleton argument where he says the judge...
I follow that Mr Davis advances that and you put this forward as a reason for not seeking to develop the common law. And I think that is 3:15, which, if it's a convenient moment, would be a good moment to break.
I don't know why I'm not picking up very well.
Is it turned on?
Yeah, it's not. Yes, it is. I think you're picking up more on this one over here.
Oh, right.
Do you mind if I reach it?
Still. Perfect. Yeah.
I put HI actually.
Yes, I think so. Actually, no, I'll do one more paragraph. I'll do one more. I don't know if your lordship still have HIH
Yes.
out. For completeness, if I could ask you to turn to page 875 and read what Lord Newey said in paragraph 76 and 77, just to finish that last point.
Yes.
And then that finishes with HIH. If I could then ask your lordships to turn up Authorities Bundle 3, tab. No. Authorities Bundle 2, tab 53. We go to Cambridge Gas. For the point that the doctrine of modified universalism and the concept of common law assistance isn't some magic wand that can be waved to make the orthodox principles of private international law disappear. This case concerned shares in a company called Navigator, which was incorporated.
Sorry, I'm obviously in the wrong tab.
I've got it at tab 53, Authorities 2, my lord. Does your lordship have it somewhere else?
Sorry, Cambridge Gas?
Yes, that's right.
Okay, sorry, I misheard. So I was in the right place. after all.
Just in terms of the facts, Navigator is a company incorporated in the Isle of Man. Cambridge Gas is a company that owns shares in Navigator. The New York Bankruptcy Court made an order under the US Bankruptcy Code which purported to divest Cambridge Gas of those shares and to vest them in a committee of creditors. And the New York Bankruptcy Court issued a letter of request addressed to the Manx Court, asking the Manx Court to recognise and give effect to that order. And Cambridge Gas, as the owner of the shares, of which it had reportedly been divested, opposed that in the Isle of Man and relied on the orthodox principles of private international law as set out in Dicey. And you'll see that from page 515 in the opinion of the Privy Council delivered by Lord Hoffman. At the bottom of the page, paragraph 12, Mr Howe's argument for Cambridge was straightforward. The New York order was either a judgment in rem or in personam. If it was in rem, it couldn't affect title to shares in the Isle of Man. If it was in personam, it was only binding on persons over whom the New York court had jurisdiction. In fact, Navigator had submitted to the jurisdiction as irrelevant. The Court of Appeal, having found jurisdiction was in personam, proceeded to enforce it against the wrong persona, etc. So his submission is, well, this just has to be determined in accordance with the orthodox principles of private international law. And Lord Hoffman says in paragraph 13 that Mr Howe's submissions as to the rules of private international law are, of course, correct if the New York order and plan had to be classified as falling within one category or the other. The appeal would have to be allowed. But their lordships consider that bankruptcy proceedings do not fall into either category. And he develops a point saying that bankruptcy is different, it's special, it's sui generis. And the reason he gives for that is in paragraph 15, where he says in the second sentence that the important point is that bankruptcy, whether personal or corporate, is a collective proceeding to enforce rights and not to establish them.
Yes, as it's sometimes put, it's a class remedy.
Yes, and undoubtedly it is a class remedy, but he says that that is such an exceptional, unique feature that it takes you out of the realm of Dicey and Morris and the orthodox principles of private international law. And he says in paragraph 18 over the page that, by reference to what Professor Fletcher had said, the common law on cross-border insolvency has for some time been in a state of arrested development, no doubt in part because in England a good deal of the ground had been occupied by statutory provisions. And then he says in 19 that the undeveloped state of the common law means that the unifying principles applied to personal and corporate insolvency have not been fully worked out. And then over the page at 518, he cites...
Yeah, it's worth noticing what he says at the end of 19. In the case of a mobile party belongs to foreign bankrupt, there's no automatic vesting. The English court has a discretion to assist the foreign trustee by enabling him to obtain title to or otherwise deal with the property. Now, of course, I appreciate that he may be there referring to the statutory jurisdiction, but nevertheless it's worth taking into account.
Well, maybe he's referring to the statutory jurisdiction. It may be that he's referring...
On the face of it, he's talking about the common law.
Yes, this broader common law notion he sets out over the page 518, by reference to African Farms, a South African decision, where he says there's a principle of active assistance. You'll see that the recognition carries with it the active assistance of the court. And then in 21, their lordships consider these principles are sufficient to confer upon the Manx Court jurisdiction to assist the Committee of Creditors to give effect to the plan. And so what he's saying is that orthodox principles of private international law don't apply to insolvency proceedings which are sui generis. If what Mr Howe had said about private international law were applicable, then the appeal would have to be
all right, it's my fault. I'm
Dismissed.
slightly lost here because our starting point here is the Immovables Rule, which is a rule of private international law. Specifically, it's a rule as to applicable law. Because what it tells you is that you must apply English law and not foreign law. But how does it help to say that bankruptcy is a class remedy?
Well, what Lord Hoffman was holding was that the orthodox principles of private international law don't apply to insolvency cases which are sui generis and which are governed instead by this principle of active assistance. It's that analysis that's then decisively rejected by the Supreme Court in Rubin, which you'll find in Authorities Bundle 3 at tab 63, where...
So just being clear, had Cambridge Gas stood, you say, well, Mr Davis might have got a lot of help from
Exactly.
it, but
Absolutely.
It hasn't.
Exactly. It would have entitled him to say, well, I'm not constrained by orthodox principles of private international law, the Immovables Rule, because this is different. It's a principle of active assistance. You can do what you like, unconstrained by these orthodox principles. But that's rejected by the Supreme Court in Rubin at tab 63. And at page 257, in the middle of the page, Lord Collins turns to Cambridge Gas. Sets out the facts. On the next page, at paragraph 43, he sets out the Privy Council's reasoning. First, if the judgment had to be classified as in personam or in rem, the appeal would have to be allowed, but bankruptcy proceedings did not fall into either category. And then over the page 44, second, the principle of universality underlay the common law principles of judicial assistance in international insolvency, and those principles were sufficient to confer jurisdiction on the Manx Court to assist. And then on page 268, at the bottom of the page, 4 lines up from the bottom, you'll see the question posed by Lord Collins is whether the court, in the interest of universality of insolvency proceedings, should devise a rule for the recognition and enforcement of judgments in foreign insolvency proceedings, which is more expansive or more favourable to liquidators, trustees in bankruptcy, receivers, and other office holders than the traditional common law rule embodied in Dicey, or should it be left to legislation preceded by any necessary consultation? And then at paragraph 274,
Page 2.
sorry, page, my lord is right, page 274, paragraph 115, he says the question is one of policy. Should there be a more liberal rule for avoidance judgments in the interest of universality of bankruptcy and similar procedures? In my judgment, the answer is in the negative for the following reasons. And he sets out his reasons, and he says at the bottom of page 275, paragraph 122, that the respondents were proposing that the issues that he'd identified be resolved not by a black letter rule like the common law rule for the enforcement of judgments, but instead by an appeal to what was said in oral argument to be the discretion of the English court to assist the foreign court.
Sorry, I've lost you. I wasn't keeping
I'm
up.
sorry, my lord.
Oh, yes, I see. Yes, 122. Yes, of course.
122. So the respondents are appealing to the discretion of the English court to assist a foreign court, and he rejects that and holds at the bottom of page 277 at 276 it's going to be at paragraph 128 that the dicta in Cambridge Gas and HIH do not justify the result which a court of appeal reached. This would not be an incremental development of existing principles, but a radical departure from substantially settled law. He says there's a reason for the limited scope of the Dicey rule as an expectation of reciprocity. Typically today, the introduction of new rules for the enforcement of judgments depends on a degree of reciprocity. EC insolvency regulation and the model law are the product of lengthy negotiation and consultation. And then in 129, he says a change in the settled law for the recognition and enforcement of judgments, in particular the formulation of a rule for the identification of those courts which is to be regarded as courts of competent jurisdiction, has all the hallmarks of legislation and is a matter for the legislature, not for judicial innovation. The law relating to enforcement of foreign judgments and the law relating to international insolvency are not areas of law which have in recent times been left to the development of judge-made law. As Lord Lord Bridge of Harwich put it in another case, if the law is now in need of reform, it's for the legislature, not the judiciary, to effect it. And then over on page 278, at 132, he says that Cambridge Gas was wrongly decided. The Privy Council accepted that Cambridge Gas was not subject to the personal jurisdiction of the US Bankruptcy Court. The property in question, shares and Navigator, was situated in the Isle of Man, and therefore also not subject to the in rem jurisdiction of the US Bankruptcy Court. There was therefore no basis for the recognition of the order of the US Bankruptcy Court in the Isle of Man. So, in other words, where you get to at the end of Rubin is that the orthodox rules of private international law are fully applicable to judicial assistance at common law in cross-border insolvency cases. The concept of common law assistance doesn't enable the court to reach a result which is contrary to those orthodox rules of private international law. That would be a radical departure from substantially settled law, which has all the hallmarks of legislation and is a matter for the legislature, not judicial innovation. And I'll give one example of that, if I may, to put flesh on the bones of the point. The judge made the point in the present case that if you are to have a common law principle of assistance in respect of immovable property in England, it's going to be necessary to decide which foreign insolvency proceedings are entitled to assistance at common law. As Lord Collins put it in Rubin at paragraph 117, what is the requisite nexus between the insolvency and the foreign court in order for such assistance to be given? It's implicit in the submissions of Mr Davies that when it comes to English immovable property, the English court should assist any foreign bankruptcy court to which the debtor has submitted by participating in the foreign bankruptcy proceedings. But as the judge said in the present case, and it might be a good idea
Well,
to...
before you go to that, before we leave Rubin,
Yes.
reliance was placed by Mr Davies on what Lord Collins said earlier in his judgment, and in particular, passage starting at paragraph 21 and following, where he identifies, I really part 25 and following, four main methods for assisting in insolvency proceedings in other jurisdictions. His first one is section 426, which you've covered. The second one is the insolvency regulation, which is not relevant for our purposes. The third one is CBIR, which is covered.
Yes.
And then the fourth one is common law, which is what you're now on.
Yes.
And reliance was placed by Mr Davies on what was said at paragraphs 29 and following. Maybe I've misunderstood you, but do you go so far as to say that in his conclusions, Lord Collins was somehow disavowing what he'd said at 29 and following?
No.
He wasn't saying the common law power to assist doesn't exist.
No. No, absolutely.
The question is, what are its limits?
Exactly. That was the question that was not really answered by Rubin, and that's answered then by Singularis, which we'll come to in a moment. But while we're here, there was reference placed in Mr Davies' reliance placed in Mr Davies' skeleton argument on paragraph 31. He didn't, I don't think, rely on that orally. The answer to the point is the one that we gave in our skeleton argument at paragraph 77, subparagraph 3, that Lord Collins was dealing only with the position in respect of movable property, as demonstrated by the fact that to support it he cited in paragraph 32 two movable property cases, Solomons and Ross and Bergram and Marsh, and it was common ground at first instance that paragraph 31 was referring only to movable property, with Mr Davies confirming I think he's talking about movables. I do not think he's really talking about immovables here. And that's absolutely right, as I say, from the analysis of the two cases cited in paragraph 32. But to come back to my Lord Justice Arnold's question, of course, we accept that there is a common law power of assistance. What Rubin establishes is that it can't be exercised in a way which conflicts with the orthodox principles of private international law. And Singularis then explores those limits further by saying that it can't be exercised in a way that is contrary to any substantive law of the assisting court, or even the public policy of the assisting court's jurisdiction. So it is limited. It's a power that exists, but it's not some wide-ranging power which replicates the statutory provisions, or which has the sort of powerful effects that the statutory assistance provisions can have. To finish, if I may, the point I was making actually before we go to Singularis, in the core bundle at tab 7, page 138 of the bundle, I was referring to what the judge in the present case said in paragraph 256, where he said that it's by no means obvious that primacy should be given to a bankruptcy in the jurisdiction to which a debtor has submitted, rather than one in which he is domiciled or in which he has his came. Indeed, in the modern international business world, it's very possible a debtor might be held to have submitted to the insolvency jurisdiction of more than one country. Submission to jurisdiction may be an unsatisfactory basis for identifying the place of a universal insolvency proceeding to which assistance should be given. If such a development is to take place, it should be the result of intervention by the legislature, not by the courts. And we rely on that in our respondent's notice to make a different point, which is to say, well, if you are going to be tempted down the route of creating a new common law power to assist a foreign trustee in respect of immovable property in England, you shouldn't base it on the concept of submission to jurisdiction of the foreign court, which is not a sufficient nexus, or alternatively, in the present case, you should decline to exercise your discretion in favour of the Russian trustee on the basis that mere submission is not sufficient and is outweighed by the fact that Mr Bedzhamov was not domiciled in Russia and had his came in England. And we maintain those submissions if you're tempted down the route of what we would respectfully submit constitutes legislation from the bench. But
I'm conscious you haven't got all that much time.
yes,
but
I'm almost done, my lord.
No, not that. I was going to raise something with you.
Yes.
You're there in the territory of picking and choosing between bankruptcies, so to speak. I raised with Mr Davies this morning the possibility, the question whether it was possible to get a bankruptcy order here, supposing that you're right on this appeal and the trustee can't do anything.
Yes.
Would there be scope for either the trustee or a creditor to come and get a bankruptcy order here and so reach the immovable property that way? Now, I don't ask for an answer now, but I would be grateful for something on that before the hearing ends tomorrow.
The answer, my lord, is yes. It's the point we make in our skeleton argument that we make the point at paragraph 12, where we say a creditor who wishes to enforce against the immovable property of the debtor in England must do so in accordance with English law, e.g. by way of an application in England for a charging order or a bankruptcy petition against the debtor in England under the Consultancy Act 1986. And we go on to develop the point in subsequent paragraphs, in particular paragraphs 40, 41, 42, and at the bottom of paragraph 42 we make the point that since Mr Bedzhamov has his comey here, the English court will have jurisdiction to make a bankruptcy order against him under section 265 of the Insolvency Act. But of course it's not limited to bankruptcy, because there is also the statutory jurisdiction to obtain a charging order relying on an English judgment and
Well, I'm sorry to interrupt you, but
Yes.
this isn't quite on point. I don't think anybody's disputing that as a general proposition, the English court has jurisdiction to make a bankruptcy order against Mr Bedzhamov. That's not the issue. The question is whether this trustee could obtain a bankruptcy order on the basis of the existing proofs.
Or whether one of the creditors who has put in a proof could say, well, that's not going to get the immovables, I'm going to petition in England.
There's no evidence before the court to suggest that it wouldn't be possible, and I think Mr Fenwick is going to deal with this in more detail. The judge refers to it in his judgment. During the hearing, VPB wrote a letter to the judge to say that anything that it obtained in the English proceedings, and that includes therefore by way of enforcement,
They'd send back to Russia.
would be sent to Russia for the...
And I really don't want you to get derailed on your timings, which are quite tight. But forget the facts of this case. As a matter of principle, if you have a creditor who has proved in a foreign bankruptcy, who finds that the immovable property can't be reached by that trustee, is it, as a matter of law, open to the creditor to come to the country where the immovable is and seek a bankruptcy order? I think Mr Davis is saying that is not possible.
As a matter of English law, it's absolutely possible. In a number of the cases, including, I think, Singularis, which we're going to go to in a moment, there's an explanation of the possibility of parallel proceedings. It's most common in the context of liquidation, where you will have what came to be described as an ancillary liquidation for the purpose of dealing with local assets. There's nothing under English law that would prevent the commencement of parallel proceedings. In fact, as, I think it's Singularis that we'll see it from in a moment.
Yes.
It's seen as part of the principle of modified universalism. It's one of the ways that you give effect to that halfway house between absolute universalism, which was more the sort of system you have under the EC regulation, and pure territoriality. Modified universalism is somewhere between the two, and one of the ways you can give effect to it is to say we'll have a parallel process here for local assets, which may or may not end up remitting those assets to principal liquidation, which was, again, as the Lordships know, the issue in HIH. But there'd be nothing under English law to stop VPB, if it obtained a judgment, from either applying for a charging order and looking to enforce that, or going down the bankruptcy route and presenting a bankruptcy petition on the basis of the judgment debt and reliance on the fact that Mr Bedzhamov...
I'm quite following that. I mean, any creditor with an undisputable debt could serve an appropriate notice and then petition.
Yes.
Yes.
Yes, there's absolutely no reason why not. And I know Mr Davies took your Lordships briefly to what had been said in some expert evidence in a different case, but we don't have any expert evidence to that effect. And in any event, VPB has written this letter to the court confirming that anything it gets will be remitted to the Russian trustee for the benefit of the creditors in the Russian bankruptcy generally.
Yeah.
The point that I think I was making before your
Yes, sorry.
Lordship asked that question related to what the judge said in the judgment at paragraph 256, where he said it wasn't clear what criteria would be applied to pick the foreign jurisdiction which is to be assisted, and that submission may not be a sufficient nexus. And I was making the point that in our Respondent's notice, we rely on that to say, well, if you are going to create a new principle, then either you should hold submission isn't sufficient, or as a matter of discretion, there's not a sufficient nexus or connection. But my primary purpose for mentioning it at this juncture is to reinforce the overall submission that I've been making, that the creation of this sort of common law rule does have all the hallmarks of legislation. It involves policy choices and is a matter for the intervention of the legislature, not judicial innovation. The next point to deal with, finally, is Singularis, which was a decision about the scope of common law assistance, and in particular on the facts of that case, whether common law assistance could be granted in the form of compelling a person within the jurisdiction to provide information. And it's in the authorities bundle 3 at tab 64. Lord Sumption deals with Cambridge Gas at page 691 of the report, just below C.
Sorry.
Sorry, Lord.
I've got a few.
1691.
Oh, 1691.
Sorry, did I misspeak? Just below C, where he says that Cambridge Gas's authority is correct for 3 propositions. The first is the principle of modifying universalism, namely the court has a common law power to assist so far as it properly can. The second is that this includes doing whatever it could have done in a domestic insolvency. The third, which is implicit, is that this power is itself the source of its jurisdiction over those affected, and that the absence of jurisdiction in rem or in personam according to ordinary common law principles is irrelevant. And then at 1693, just below C, he says that...
Yeah, I'm sorry, just before you go on, you see, this is what's puzzling me about this aspect of the case, because Lord Sumption's way of articulating the point is helpful. He says the absence of jurisdiction in rem or persona, or in persona according to ordinary common law principles, is irrelevant. And of course we know that's disapproved, but we're not speaking in the present case of an absence of jurisdiction under ordinary common law principles. To the contrary, we're talking about the presence of in personam jurisdiction in accordance with ordinary principle. Because Mr Bedzhamov is here.
Yes, absolutely. We're also talking in the scope of this appeal about the rights, legal and equitable, of Mr Bedzhamov to immovable property in England. The relevance of the Immovables Rule is that whatever may have happened under foreign bankruptcy law is irrelevant. There's no applicable statutory exception to that. That's therefore the position. He's entitled to full ownership rights in respect of the Belgrave Square property. Of course, the court has in personam jurisdiction over him, but it would be, in my submission, utterly extraordinary and exorbitant for this court to make an order, presumably in the nature of an injunction, compelling a person within its jurisdiction who is under English law the full owner of immovable property in England to deal with it inconsistently with his property rights under English law, to convey it to someone who has under English law no right, title or interest whatsoever in that property. And the way...
I forget the facts of Singularis. Was there in personam jurisdiction in Singularis?
Yes, absolutely. It was a company being wound up in the Cayman Islands. The auditors were in Bermuda. The Cayman liquidators went to Bermuda to seek an order for the provision of information. At first instance, the judge relied on Cambridge Gas to say, well, in a Bermuda liquidation, there's a power to compel auditors to provide information. That doesn't apply because we're dealing with a Cayman liquidation, but according to Cambridge Gas, I can apply that legislation by analogy as if it were applicable and order the auditors to hand it over to the Cayman liquidators. And that's the point principally dealt with by Lord Collins in very strident terms, where he says that's impermissible legislation from the bench. The point that Lord Sumption deals with is slightly different, which is what is common law assistance, how does it work, and what are the limits? And in essence, what he holds is that if the court has a power inherent in it, it can potentially be exercised by way of judicial assistance, but it must always be exercised in a way that is subject to the substantive law and policy of the assisting court, and cannot be exercised in a way that is contrary to that. So looking at the facts of Singularis, for example, if it were the case that you had a Russian trustee in bankruptcy coming to England saying, I want information from the bankrupt about immovable property in Russia, then it may well be that the English court says, we have a power to compel provision of information. Singularis spells it out. There's nothing in what's being sought that's in any way contrary to any substantive law of England. It's not contrary to any of the orthodox rules of private international law. It's not contrary to any public policy in England, and will therefore extend assistance in the terms sought. The propositions in Cambridge Gas that are disapproved are the second and third, and you see that from what's said at page 1693 at E. The second and third propositions for which Cambridge Gas Authority cannot be supported. And he says the first proposition, the principle of modified universalism, has not been discredited. And then at 1694, he says that after the quote at F, the principle of modified universalism is part of the common law. It's necessary to bear in mind first that it's subject to local law and local public policy, and secondly that the court can only ever act within the limits of its own statutory and common law powers. What are those limits? In the absence of relevant statutory power, they must depend on the common law, including any proper development of the common law. And at the bottom of that paragraph at H, he says the fate of the application depends on whether there being no statutory power to order production, there's an inherent power at common law to do so. And then at paragraph 22, he cites Norwich Pharmacal in support of the proposition that there is a jurisdiction.
Well, he goes on in 23 to point out that this is not a Norwich Pharmacal case.
Exactly.
And what he does in 23 is to say that the common law power should be developed and extended.
Yes, absolutely. It's not inconsistent with any substantive law or public policy of the assisting state, and it can be developed. So he says if you find an inherent power in the court, although it may not be a traditional case for the exercise of that power, modified universalism can supply the reason for exercising it in a cross-border insolvency context. And he says at 1696, just between C and D, that the principle of modified universalism is a recognised principle of the common law. But he has already made the point back at 1694 at F that it must always be exercised subject to local law and local public policy. And he makes that point again at 1697 at G, his fourth point. The power is subject to the limitation in African Farms and HLH and Rubin that such an order must be consistent with the substantive law and public policy of the assisting court. So it's entirely consistent with what's being held in Rubin, disapproving Cambridge Gas, that common law assistance, as I said, is not magic wand that makes the orthodox principles of private international law disappear. It must be exercised in a way that is consistent with those orthodox principles and indeed any other substantive law and public policy of the assisting court. And that's why, as I say, it's proposition 4C is that common law assistance can't overcome the Immovables Rule because it is subject to the Immovables Rule. And the court can't create any new common law exceptions to the orthodox rules of private international law because that has all the hallmarks of legislation and is a matter for the legislature. The final point to deal with is Cooperman in Authorities Volume 1 at tab 26, the decision of Mr Justice Astbury on an ex parte application. It was unopposed. The judge didn't have the benefit of adversarial argument. The right cases weren't cited, and it was an unreasoned decision. In our submission, it's not authority for anything. It doesn't make sense on its face, and it can't, in any event, survive Rubin. It's involved a Belgian bankruptcy and leasehold property in England. And the submission of Tyndall Davis for the applicant at the bottom of the first page was that the order of the Belgian court cannot affect immovable property, whether freehold or leasehold, situate in England. And that's, of course, correct. But, and this is where, in our submission, and as the judge held, the reasoning goes wrong, but the English court will assist the foreign trustee in a proper case by appointing a receiver to the English property. And he goes on to say the bankruptcy out of jurisdiction cannot be served, and then it's reported the respondent was not represented. Before we get to the judgment, the proposition of counsel, as you've seen, is that the English court will assist the foreign trustee in a proper case by appointing a receiver to the English property. If you look at the head note, only one case is referred to in support of that proposition. At the end of the head note, Bergeram and Marsh. We've got that behind tab 20. And you'll see from the final 3 lines of the head note in that case, tab 20, it was held that the defendant's movable property in this country vested in the Belgian trustee, and a receiver must be appointed. It's a case about movable property, and that's apparent from the final lines on page 197 as well, where it said, I hold the movable property of the defendant in this country vests in the Belgian trustee, and a receiver must be appointed to protect the property until an ultimate decision is arrived at. And as your lordships know, movable property is subject to a different rule, which the judge explained in his judgment in the present case at paragraph 186, by reference to Dicey Rule 216. The fact that the court can appoint a receiver in cases where the bankrupt's movables are vested in the foreign trustee says nothing whatsoever about the position in respect of immovables. So, turning back to what counsel submitted in Cooperman at tab 26, where he says, well, the court will assist the trustee in a proper case by appointing a receiver to the English property. He's relied on Bergeram and Marsh. That's about immovable property. And what Mr Justice Astbury says on this unopposed ex parte application, where the bankrupt hasn't been served, is I make an order that Maitre Donné be appointed without security receiver of the leasehold property in question with authority to sell and retain the proceeds as trustee. And that's not even a reasoned decision, that's just his order. There are no reasons given. Mr Justice Astbury doesn't explain where that jurisdiction has come from. What he's relied on is a case about movables. It seems to be authority in our submission for nothing at all. That's why, as we say, the judge was right to hold that if it is authority for anything, it's wrong and shouldn't be followed. But in any event, it can't survive Rubin and Singularis, which explain the proper basis for the limited scope for common law judicial assistance. Unless your lordships have any questions, those are my submission.
Just circling round, we've got section 37 reflecting an equitable power.
Yes.
The power itself is formally unconstrained, and obviously the court has in personam jurisdiction over Mr Bedzhamov. More than that, I forget the precise details we see from the Privy Council recent decision. Convoy. A broader approach being taken to section 37. So what, in brief, is the reason why section 37 shouldn't be exercised here?
Because the trustee has no right recognised by English law to the bankrupt's immovable property in England. And that position isn't changed by the Broad Idea and Convoy collateral decision, where Lord Legate, as my Lord says, explains that the jurisdiction under section 37 may be exercised to grant a freezing order on the basis of what he describes as the enforcement principle. It's how he deals with Siskina. He explains that it doesn't matter in a freezing order case that the claimant has no present legal or equitable right to the property that's been frozen, because the court will preserve the property so that it's available for enforcement in the future if and when the claimant obtains a legal or equitable right to it. So the principle in Convoy collateral is simply saying the court's jurisdiction extends to holding the ring, preserving the status quo, so that someone who doesn't currently have a legal or equitable right will find that the property is still there available for enforcement in the future as and when such a legal or equitable right is acquired. The reason that doesn't assist Ms Kireeva in the present case is because she doesn't have any legal or equitable right recognised by English law in respect of the immovable property in England, and there's no basis on which she's going to be able to get one in the future, because section 426 doesn't apply, Russia's not a designated country, and the CBIR don't apply, and the common law power can't be assessed in a manner which is can't be exercised in a manner which is inconsistent with the orthodox principles of private international law.
Another miscellaneous point. This property, as I understand it, is not let out. But suppose it were let out, would there be any objection to a receiver being appointed in respect of its rents?
That would be covered by one of those two outstanding applications. There's the application relating to movables generally. That is opposed. We haven't yet had a chance to put forward the arguments. It hasn't even been listed for a hearing. But the principal argument on which we rely by reference to the way that the Movables Rule is put in Dicey is that the foreign assignment operates as an assignment of the bankrupt's property, the bankrupt's movable property in England at the date of the foreign bankruptcy order. And so we're saying there's a relevant cut-off date that the foreign trustee, if recognised, may get the movable property that's in existence at that point, can't get after acquired property, and there's a dispute about that. Mr Davis says the opposite and cites some Australian cases, and we began to have that argument at the consequentials hearing before Mr Justice Snowden said, look, that's not part of this application, make a separate application, it'll be listed before Mrs Justice Falk. And I think, I don't want to anticipate my Lord's next question, but the same point arises in respect of the proceeds, where, as I say, that's subject to a separate application that hasn't been heard yet. Our position is that, as a matter of English law, the person who is entitled to an asset is entitled to the proceeds of sale of that asset. The ownership in the property follows through to ownership of the proceeds. And again, we haven't argued it. We don't have all the cases in the bundle. We've got one of them here purely by happenstance because it was put in on a different point. But for example, we'd be relying on what's said in Freakin Lord Carvery, where Lord Selborne.
Sorry, which authority?
Freakin Lord Carvery. Lord
Yes,
Selborne holds that as to the proceeds of the house in Belgrave Square, purely a coincidence that it involved another house in Belgrave Square, they must necessarily follow the law applicable to the house itself. And so he holds that because by reason of the Immovables Rule, the house the ownership of the house is governed exclusively by English law and not affected by anything done under a foreign law, then the position is the same as to the proceeds. But as I say, all these points are
for the future. Just thinking around it for a moment, if this were an English bankruptcy, there would be a potential to apply for an income payments order to catch, so to speak, a future movable within limits. And as you say, there could be after acquired property regimes, and you say, well, none of that applies here.
Well, and again, though, that's part of what we'll be
arguing about
and relying on, because just to take your Lordship's reference, there are cases where a bankrupt in an English case sells a property and says that the trustee can't have the proceeds because they're after acquired property, and it's held, no, the person who had the right to the house is entitled to the proceeds. By that point, the trustee was entitled to the house, therefore he's entitled to the proceeds. We have the converse of that, where
you
we
say
say
it's the same the other way.
bankrupt is entitled, exactly. So that's, yes, I'm afraid, yet to be argued. It had been suggested at one point that they might be heard and decided by Mrs Justice Falk before the hearing of this appeal. Unfortunately, there wasn't enough time for that, so as I say, they haven't even been listed for a hearing yet.
Yes, I see. I don't detect anybody else wanting to ask you many more questions.
In which case, I hand over.
Mr. Fennick.
Lord, may I briefly take stock? I'm about 25 minutes behind where I wanted to be.
Yes.
So I may have to take about 15 minutes from my reply in order to make sure that I...
The timetable for reply is relatively generous, is it?
At the moment, I'm due to finish by 11 o'clock tomorrow. Leonard Friend to finish by 12:15 with my having a 45-minute reply. I will therefore have to truncate my reply if necessary, if I find that I can't complete my submissions before about 11:15 tomorrow morning.
Yes.
I steal only from myself,
Yes.
so long as I've warned the court what I'm going to do, and Leonard Friend as well.
Yes. And I assume it would be a good idea to make use of 5 minutes, even though it's only 5 minutes. If time is short or not really.
To start, your Lordship's intending to rise at 4:15,
Yes.
right? May I take 5 minutes?
Yes.
Thank you.
Possibly you may even make it 10, subject to Lord Justice Arnold and Lord Justice Stuart-Smith.
Oh, I'm grateful. That enables me to begin. Lord, it's really difficult to overstate the impact that the late arrival of the trustee has had on these proceedings. As I will demonstrate, she knew about them or their likelihood, although she doesn't accept that, from the outset. We proceeded not only through the steps which I outlined in my very brief opening, but to the stage where we were due to be at trial next in January, and at the point at which my client, as he was permitted to do under the worldwide freezing order, was seeking to raise funds from his assets, as to which no proprietary claim had been made, in order to continue his defence of these proceedings and for his living expenses. As a result of the intervention of the trustee. The sale has been lost, the trial has been lost, and the trial procedure at which Mrs Justice Falk and Master K had spent considerable time and effort to get it into order has been totally disrupted. One is entitled to ask the question of why A1, the rather unusual commercial funder of VPB and the DIA, Deposit Investment Authority, which brings the claim as liquidator of VPB, should, at a time when they could expect a trial and judgment on a claim for £1.3 billion, decide to fund the trustee who had been sitting quietly in Russia since 2018 in order to intervene in these proceedings. And it's plain and obvious that the purpose of that was to prevent my client from realizing the asset which the court had anticipated in the carefully balanced terms of the WFO would, if necessary, be available for him to fund his defense as well as for living expenses. In those circumstances, one is entitled to, and I will be inviting you to look firstly at what was said by and about the trustee at the time that my Lord Justice Arnold was persuaded to make the WFO and the search order, and what is said now about the trustee and her involvement and his reasons, and also about what was said at the time about the vast majority of the debt in respect of which she's been appointed, namely the VPB £30 million claim, the unjust enrichment claim, both at the time in 2019 at the freezing order and what is said now. I think if I'm allowed the second 5 minutes, I'm going to use those to show you what was said about the trustee at the time of the WFO, which is in the additional bundle, and we can take it quite quickly. Within the material produced by Mr. Phillipson in his very, very lengthy affidavit in support of both orders, at tab 2, page 3 of the bundle, there was included a letter from the trustee outgoing, which appears to have been directed to VPB or the DIA, although it doesn't say so. It's from the financial manager, Ms. Kireeva, explaining that she had been appointed because Mr. Bedzhamov was declared insolvent. Procedure of sale of debtor's property was introduced. She was approved as financial manager. Procedure of sale continued for 6 months. And the final paragraph, since bankruptcy estate under the bankruptcy proceedings of Mr. Bedzhamov lacks funds as well as lacks other sources of funding, the financial manager is not able to institute any legal proceedings at all, including in the UK. So, for some reason, as to which we have no explanation, she was driven to write a letter, which it must be assumed she expected to be used for some purpose, to say that she was not in a position to bring proceedings, including in the United Kingdom. If we then move to tab 3, within the first affidavit of Mr. Phillipson, we can go first of all, please, to page 12, and at page 12, starting with paragraph 259, I'll come back to the unjust enrichment in a moment. He says, Mr. Bedzhamov is currently the subject of bankruptcy proceedings in Russia, in which Mr. Bedzhamov has already been declared bankrupt. Then the petition against VTB Bank 24,
I'm sorry, I must be on the wrong page.
Page
Read
11.
the page again.
Page 11.
All right.
So,
Yes, yes, thank you.
259, 260, 261. Then if we go to the next page, 12, we're on to paragraph 461, page 185, impact of Mr Bedzhamov's bankruptcy in Russia. This is in the full and frank disclosure section. Describes over the page how they were commenced in January 2017, made bankrupt July 2018, took office. Russian bankruptcy not automatically recognised by the English court. And at the bottom of that paragraph, Mrs Kireeva has confirmed to the bank, so it was to the bank in her letter of the 18th of March, a reasonable lack of funds, she's not able to initiate any proceedings. I note he's showing no sign of cooperating. As matters stand, the prospects of Ms Kireeva seeking the recognition of GB's bankruptcy in this jurisdiction appears to be very low indeed. It then goes on to deal with the model law, various reasons why that wasn't going to work. And if we go on to page 18, perhaps we should start at 17, where they give their explanation, 475. Unlikely that she could be recognised pursuant to the model law. A route to such recognition might be available at common law. This would be on the basis of submission to the Russian proceedings by Mr Belchik. But even if his bankruptcy was recognised in this jurisdiction, that wouldn't affect his liability to VPB. On the contrary, upon completion of the Russian bankruptcy proceeding, Mr Kulkov's report confirms Mr Bedzhamov would remain liable to a VPB and would not be discharged from the liability. So stating in terms that he could be sued on the very self-same debt if not paid. Over the page 18, even after completion of this stage of the bankruptcy, certain liabilities remain undischarged. Accordingly, as a matter of Russian law, a GB will not, upon completion of the relevant stage, be released from his liabilities. Bankruptcy would not prevent, I think it says GB, but it means VPB from pursuing such claims against him in these proceedings. Further, the bank is content to undertake to inform Ms Kireeva of any relief granted pursuant to this application, so that she might make any representations she considers appropriate, whether directly or related to the court or the bank, at the return date hearing. May we next look at tab 424. This is a worldwide freezing order, and it's important to note that that freezing order contained at page 24 the very first asset in respect of which is a prohibition is 17 Belgrave Square and 17 Belgrave Mews. So right there, front and centre. If we then go, of course it contains the usual exceptions for living expenses and legal advice, page 28, paragraph 11. Finally, at A/5, the search order made on the same page. If we go to the undertakings of Schedule C, which is page 55, we can see that the VPB undertakes until after the return date, it won't, without permission of the court, use any information or document, etc., or inform anyone else other than Yuri Rushkov, who was the trustee of Mr Bedzhamov's sister, and Lyubov Kireeva, Mr Bedzhamov's trustee, of these proceedings, except for certain purposes. So, right from the outset, she was to be informed. She'd written a letter, and the court was, in my submission, persuaded to proceed with a freezing order and steps for the trial of this matter on the basis of what was said. You can ignore Miss Kireeva, and I'll explain why that's important if I may tomorrow morning.
Yeah. Very much. So 10:30 in the morning.